Hello everybody. I just found this online, so we're gonna go through this. So this is regarding Letecia Stauch, and she had filed for an order to continue the preliminary hearing, and this is the response. So it says, this matters come before the court pursuant to Stauch's motion to continue the preliminary hearing. The matter had been previously scheduled to proceed to approve evident presumption great and the preliminary hearing on June 5th, 2020. That Mrs. Stauch filed a motion to continue alleging a change in jail visitation policies that occurred on or about May 4th, 2020, which she claims interfere with her ability to meet with her counsel. The court only became aware of the change in the jail policy after Stauch's motion was filed in the case. So we're going to go through this. You can pause it and read all this yourself if you like. I'm just going to try and jump to some of the points in here that the defense counsel alleges that they have not been provided with the autopsy report and other discoveries. The court grants Stauch's motion to continue the preliminary hearing. While the proof evident presumption great and preliminary hearing are vacated, the June 5th, 2020 9 a.m. appearance date will remain on the docket, and this matter will proceed to a status conference to determine the best method for proceeding forward in light of the current conditions. So, the court grants Stauch the motion to continue for the preliminary, but the proof evident presumption great and preliminary hearing are vacated. The June 5th, 2020 9 a.m. appearance date will remain on the docket. This matter will proceed to a status conference. Okay, it just goes on to say that the court is also aware that the jail has again recently changed its visitation policy, and that the defense counsel are ordered to contact the jail upon receipt of this order to determine what those changes are and whether they will still be proceeding with Stauch's D11 motion for video access to a client. Okay, it says the defense counsel claims that they have not been provided with discovery to include the autopsy report, DNA results, and wiretap. Counsel for both parties will be expected to address these issues at the time of the status conference. So they're still going to have a status conference to, from what I understand, to get another date to continue the preliminary hearing. So the preliminary hearing's not going to go on, but it's going to remain on the docket, and it's going to proceed to a status conference to determine the best method to proceed. Oh, okay, there's another thing that came out too. I'm going to go and check that. But this is the update as of the 27th of May. So it looks like the court has granted Stauch's motion to continue the preliminary, but they're going to go forward. It's going to remain on the docket. They're going to go forward to proceed with a status conference. Okay, so we'll have to check out the other document that's been uploaded, and we'll see where it goes from there. Okay, so here's the other document. This is the D12, the defense's supplement to D11 and D10 and D11. And this goes on to say that Letecia Stauch, through counsel, files a supplement to the previously D10 and D11 in order to update the court and the prosecution regarding the issues to be litigated on June 5th. So this is what they're going to argue on June 5th. Prior to May 4th, the Colorado Springs Criminal Justice Center allowed 1 to 2 hours of visitation via remote video between Ms. Stauch and her counsel. On May 4th, the Colorado Springs Criminal Justice Center abruptly changed their policy and prohibited all remote video visitation for Mrs. Stauch and all inmates with her security designation. On May 12th, the defense filed D10 and D11 to request a continuance of the preliminary hearing and request that the court order the jail to allow visitation via video during the COVID-19 pandemic. On May 18th, the Colorado Springs Criminal Justice Center modified the prohibition regarding professional video visitation. The new policy attached as Exhibit A to this supplement allows for counsel to schedule a remote video visitation with Ms. Stauch after 8 p.m. On May 18th, immediately after receiving the updated visitation policy, the defense team scheduled a meeting with Ms. Stauch via video at 8 p.m. and proceeded with a 90-minute professional video visit. As the May 18th professional visitation policy now allows counsel to visit Mrs. Stauch via remote video visitation during the COVID-19 pandemic, the defense acknowledges that D11 is currently moot. The defense will work with the Colorado Springs Criminal Justice Center to schedule regular video visits with Mrs. Stauch, and the defense hereby withdraws the motion D11. In the event that any complications arise that require future court intervention, an appropriate updated pleading will be filed. Mrs. Stauch files this motion and makes all other motions and objections in this case, whether or not specifically noted at the time of making this motion or objection, on the following grounds and authorities: due process clause, the right to a fair trial by an impartial jury, the rights to counsel, equal protection, confrontation and compulsory process, the right to remain silent and to appeal, and the right to free from cruel and unusual punishment pursuant to the federal and Colorado constitutions generally, and specifically the 1st, 4th, 5th, 6th, 8th, 9th, 10th, and 14th Amendments to the United States Constitutions, and Article 2, Sections 3, 6, 7, 10, 11, 16, 18, 20, 23, 25, and 28 of the Colorado Constitution. So there you go. That's what's been filed. So it looks like they are still going to be going to court on the 5th, but that is just going to be to figure out what they're going to do regarding the preliminary and whatnot. So that's where things stand. Okay. I ask that you like, subscribe, and hit that notification bell, and that way you will be updated on any new information that comes out. Thank you for watching. Bye-bye.